So another question is kind of along a different vein, but tangentially related to that is related to child support. And if someone was laid off, so this isn't a new phenomenon. This has happened in the past, but there's a large amount of people that are going through work transition right now as companies are dealing with or trying to deal with what's going on currently. So Kelley, can you elaborate on what clients are asking there?
Yeah, I mean, generally speaking, the question is around, I've been laid off from my job and don't have any income as of right now, and I can't afford child support. Do they have any option to get some sort of forbearance on that amount that's owed? Or, and what would that process look like if they were to try and get some sort of delay in those payments?
Holly, you want to jump in and try to respond to that?
Sure. So it's important that parties move quickly if they are laid off or terminated when it comes to child support modifications, because there is a statute in fact that says the courts cannot retroactively modify child support. So again, I don't mean to speak in generalities because we are addressing specifically coronavirus, but we've seen this. I'm sure that Toby and Katie could say, talk on more than a handful of cases where people come in 6 months after they've been terminated or laid off, and they say, well, now I'm 6 months behind in child support because I haven't been able to pay because I'm not employed. So I need to go back and get those arrears wiped out and get my support changed. And we say, I can't change the past. I can help you moving forward and we can work on the future, but I can't erase what has happened. Those arrears exist and they are not going to be expunged. So if there is a significant change in employment or compensation such that your ability to pay child support is affected, now is the time to act, because we need to file and serve the motion. That's when it's effective. When you file and serve that motion on the opposing party, the court, even if we can't get you into court, even if this shutdown affects how soon we can get you in for a hearing, let's say the hearing doesn't happen till June, but we can serve them by April 1st, the court can look back to the service date, and that's not a retroactive adjustment because that goes back to the date of service. So we would not want to set a person up for accumulating a arrearage and a back pay on child support because of a job loss. Let's protect people who have been significantly financially impacted by this crisis, because it's understandable if you're not making money that you can't pay support at a level that you were previously expected to.
Toby, anything to add there as it relates to how this is handled in Wisconsin?
I wouldn't have said anything differently. It's the instant you file, that becomes our starting point, and we need to get everyone served as fast as possible because that gives us flexibility. The Court of Equity would allow for that.
Katie, any difference in Illinois? I would imagine they handle it similarly.
They definitely handle it similarly, and everything that Holly indicated applies to Illinois as well. In these types of instances, the sooner you can act and the sooner you can get something on file, the better, and service to the other party to give them notice of the fact that you're requesting to either modify the child support based on a job loss, or there's also something called an abatement, so you can put child support payments on hold for a period of time. And I think that, any type of economic impact from this pandemic, I think a judge would absolutely understand and consider that in terms of child support payments.
So 2 follow-up questions on that. So I know we've gotten calls related to the specific issue where they reached out to this child support agency, and they were not able to get through, or it wasn't like they weren't getting the help that they needed. So that's a question. And then the second one would be more of an obvious question as it relates to our process server still working and during this time. So people are probably wondering why we're not all sitting at home. So if any of you could talk about how we're deemed as an essential service, that would also be helpful. So Holly, you want to talk about the process server piece or the what if child support the agency isn't facilitating that?
Yeah, and the child support agency is not a modifier of child support. You know, they are the facilitator of the payments. So they are in charge of kind of paper pushing the court order to the employer where the wage assignment will take place. And they do a checks and balance of, does the money come in? And then they, you know, do the direct deposit to the recipient of the support, but they are not going to be filing any sort of motion to modify child support on behalf of a payor. So that is either the payor's responsibility if they are doing it without an attorney, or it's the attorney who represents the payor. But nobody's doing that on your behalf. There's limited exceptions to that rule if the state of Wisconsin would be a party of interest and there's, you know, public assistance involved. But again, those are rare occurrences. Generally speaking, that is, no one is going to be taking that initiative except for the payor or the payor's lawyer. So that's to answer that question.
Katie, so Katie, is that the same in Illinois as it relates to child support agency down there?
That is, I definitely think if you're the person who is the payor and you're obligated to make the child support payments, reaching out to healthcare family services or even state agencies is not going to be enough. You've got to either on your own behalf or by way of an attorney, you have to have someone file that petition on your behalf seeking to modify or abate the child support. Otherwise, the judge, I don't think a judge would think that that's enough. You've got to get something on file as quickly as possible.
Toby, could you talk a little bit about the process server question and kind of how we're deemed from a service perspective?
Sure. Well, I mean, just speaking locally, process servers are still working. They're deemed essential services, just as the order indicates. I'm actually scrolling through the order right now. It's what's the number? It is Article 13U. Itemizes specifically what professional services are. Professional services such as legal or accounting services, and the process server falls under that. You know, we're active, and you know, the notice element doesn't disappear because we're in a pandemic.
Right.
You know, notice is the most unsexy, most important thing you learn in law school about civil litigation. So process servers are still active. They're still working. I do believe that they are taking the necessary steps and precautionary steps to, you know, to be safe. You know, they're keeping, you know, that social distance of 6 feet. They're communicating effectively. Typically what they're doing is they're calling people ahead of time and saying, look, I need to serve you. Is there an appropriate time? What I'd like to do is kind of knock on the door, set it on the doorstep, see that you take it, you know, et cetera, et cetera. So they're part of the machine. They're still functioning.